Okay, so Al is still not here. So at that point, Laura Rusk, the vice chair, will proceed as chairwoman this evening. And Laura, if you want to delegate the preliminary matters to me, I will proceed.
Yes, please, Jay.
Call to order, roll call. This meeting is called to order at 6:10, Tuesday, January 19th, 2021, by members of the Sawyer County Board of Appeals, Laura Rusk,
Here.
Mark Olson,
Here.
Dee Dublis,
Here.
Steve Kelsey. Here. Al Gerber. Finding Al Gerber not present. From the zoning board, Jay Kozlowski, myself, zoning administrator, and Pat Brown, assistant zoning administrator. Those persons desiring to give pertinent testimony will be afforded the opportunity to do so as recognized by the chairwoman. Those persons will clearly state their full name before giving testimony. Each hearing will follow this order: reading of the application, submission of the file to the board, applicant's statement and presentation of evidence, testimony to those in support of the application, statements from person in objection to the application, rebuttal as permitted by the board, and decision by the board. Orderly procedure requires that each side will proceed without interruption by the other. All testimony will be addressed to the board, and there'll be no questions or arguments between individuals. Any persons aggrieved by the decision of the board may appeal to the decision to the circuit court within 30 days of the date following the board's decision letter. The day following the signing of the board's decision letter is the first day of the 30-day appeal filing period. Statement of hearing. Public hearing has been published as a Class 2 notification in accordance with Chapters 90 and 85 Wisconsin statutes and the Sawyer County Record and the Sawyer County Gazette. Public hearing will follow this order: variance applications, new business, and adjournment. We have no new variance applications this evening. We do have an appeal hearing. A hearing in the Town of Round Lake Owners A&D Contracting and Development LLC and SMM Properties LLC, all in part of Government Lot 2, Lot 1, CSM 36-290, number 8480, and Lot 2, CSM 36-290, 8480. Section 30, Township 41 North, Range 7 West, parcel 024-741-305239, zoned residential recreational 1, 3.06 total acres, development of lands in the Town of Round Lake west of Sandy Beach Road. Appeal is for the zoning administrator's approval of certified survey maps for the development of the lots. The approval of the certified survey map is in question is an appeal of the Sawyer County zoning ordinances for the following reasons. The certified survey map violates section 4.0 parent 1 of the Sawyer County subdivision control condominium ordinance. And 2, the approval of the CSM is in violation of the Department of Natural Resources determination with regarding to wetlands present on or adjacent to the subject parcel. As per additional email transcriptions, this was from Ryan Carey, who was legal representation for Ian Dozier. This is then sent to Rebecca Roker, who is the zoning administrator's legal counsel, as well as John Carlson, who is the Board of Appeals legal representation. Again, from Carey, my client informed me last week that he no longer wishes to pursue the appeal filed with Sawyer County BOA. He made contact with the developer, and based on the information provided to him by the developer, Dr. Dozier has determined that pursuant of the appeal is unnecessary. Please advise what Sawyer County needs from our office to formally remove the appeal from the agenda. We then have a scanned document signed with no original return to our office at this point, but a signed scanned document dated January 12th, 2021. I, Ian Dozier, formally withdraw my appeal application 20-001 as dated above. Reasons why: primarily because the DNR is no longer supporting their original description of lands in question. Specifically, that this is our property as a wetland adjacent to navigable water. Again, signed Ian Dozier, January 12th, 2021. Again, we had reached out to Mr. Carey to see if that original signed withdrawal had been sent out, and no communication with him since then. It would be up to this committee to accept the scanned signed withdrawal or to proceed, or to postpone until we receive the signed original.
Oh, now you're waiting for me to say something.
That'd be
Well,
correct, Vice Chair.
This is Mark Olson. I guess in my experience, signed scan document in today's world is pretty much been acceptable as long as there's a follow-up mailed. So I would have no problem accepting the scanned document as his withdrawal letter being official.
Is that a motion?
Yes, I would make that motion.
Okay, Mark, I am in agreement with you and I will second that motion. Is there any discussion on the motion?
Nope.
Barring any discussion on the motion, I would call for a vote. All in favor?
Aye.
Aye. Opposed? Motion carried.
Motion carried to withdraw appeal application, new business. We have a reconsideration, or what we could also consider a rehearing of Betts variance, variance number 20-002, Mullen Betts. This is a reconsideration or rehearing of a public hearing in the town of Round Lake that was previously heard of variance 20-002, part of government lot 5, section 30, township 41 north, range 5 west, parcel 024-541-305516, 1.54 total acres zoned residential recreational 1. Previous variance was approved for a 10 by 14 addition on November 17, 2020. Application is for the reconsideration or a rehearing of a 9-foot by 15-foot 6-inch attached bathroom and screen porch addition onto an existing principal structure located 26 feet at the closest point to the ordinary high water mark of Moose Lake. The proposed expansion would be 50.5 feet to the ordinary high water mark. This is requested as section 6.1 of the Sawyer County zoning ordinance, shoreline wetland protection ordinance. I got a few more things here. We would require prior granted of variance for any structures located closer than 75 feet to the ordinary high water mark with no other exempt structures or reduced setback provisions. As per the town of Round Lake, which also had reheard this, motion was approved. Rolf Hansen, Kay Wilson, supervisor, Sandra Shara, supervisor, Virginia Chaybeck. No additional comments. Signed, Kathy McCoy, town clerk. I also have an email from Barb Betts. I don't know if it matters, but since the size was reduced considerably at the last Board of Appeals meeting, it will no longer be a screen porch. And that is all the information I have. This was not remailed out to the adjacent property owners for this one. But looking at the adjacent property owners list that was sent out back in November, 5 were sent out, 3 were returned, all 3 with no objections. So I'll turn it over to the board, but I do want to kind of state that we've heard these types of rehearings or reconsiderations in the past, and really it's kind of up to this committee whether or not you want to rehear this. Again, we're granted for a 10 by 14 addition at that November Board of Appeals meeting. This now is for a rehearing for a 15.5 by 9, which is actually less square footage than the 140 square feet that was initially approved. And then again, if the committee has any questions, you can certainly ask me, and I do believe the owner, Barb Betts, is also online for available questions.
Yes, and James Mullen.
Ms. Chairwoman, I would like to make a motion to make a determination of our jurisdiction and power on this. Normally, we don't ask that, but it's in our bylaws that would be the next step before we hear from the people. But I guess my question is, and it correlates later on to the other discussion we're having, but under our bylaws, it's very clear that in section 10.0 that we have a 1-year refiling rule, which is 10.1, that states no matter which has been acted upon by the board concerning the same part of the same property shall be considered again with 1 year from the date of the action, except as hereinafter provided, which in 10.2 says reopenings and rehearings limited. The board may not reopen any case upon which a previous hearing has been held except to correct a manifest error, which that has not occurred in this case. And in 10.4, it talks about reconsideration on a board motion, which states a decision of the board may be reconsidered by motion to reconsider made at the same meeting, which may be immediately disposed of without further notice. So if this is a rehearing, depending on what verbiage we want to use in this, we're not allowed to rehear it. It's been held and closed. And if it's considered a reconsideration, we have no authority to rehear it again because it was not brought up at the same meeting. So I don't think we can even hear this case myself based on our bylaws.
Okay. I certainly am not as familiar with all of this as you are, Mark, so I have to take your word for it. Jay, input?
So I'm looking also at the bylaws and under section 10.6. So I guess it's a matter of interpretation is whether or not you read each section. So 10.4 talks about reconsiderations on board motions. A decision of the board may be reconsidered by motion to reconsider made at the same meeting, which may be immediately disposed of without further notice. That's section 10.4. Then you go down to 10.6. It talks about procedures for reconsideration. A simple majority vote shall be sufficient to reconsider a previous decision. If a reconsideration is refused to an interested party who has requested a reconsideration, the board shall enter onto the minutes the basis of the request, the reason why it was refused, and vote on the board members thereon. So are there different forms of reconsideration? One being that needs to be made in the same meeting, and another that simply requires a majority vote to reconsider a previous decision. So again, it's a matter of interpretation on whether or not 10.4 is tied to 10.6 or if they read as separate sections within the bylaws.
Well, my interpretation, I kind of disagree with you. I think that's the procedure you have to use when you're asking for a reconsideration during the same meeting is the way I read it. And I understand your reading of it. But then again, I go back to the 1 year rule, and mainly it's allowed for a manifest error for a rehearing and a reconsideration. I'm looking at that's the procedures that you use when you're asking for a reconsideration at the same meeting is my interpretation. I guess my point on it would be, this is a minimal change they're asking for, and if we start allowing these, I've been on the Board of Appeals for a long time, and I can remember one that, I don't remember one on the Board of Appeals, but I could be wrong on that. Now I've seen them at the zoning committee where they've been brought back. But I guess my point would be on why I'm asking for the jurisdiction is because if we if we start allowing this, when's it going to end on something like that? I went back and re-listened to our meeting notes and the audio of our last meeting, and we were very clear that the three-season porch was out. We could not justify granting variance on that. So then we ended up, I was actually smaller and outvoted. They went for a larger size, but it was our intent was very clear that we made it larger to allow them to have a bathroom and a clear entryway into the house. So it wasn't just a bathroom and you walked right into the bathroom into the house. That's why the size got reduced. You look at in our documents, the current plan, and I didn't measure it out with a ruler, but basically cut it in half, which is 7 feet. They got approximately a 9-foot by 10-foot entryway, which is a pretty big entryway and a tiny bathroom. The intent that the board passed this on was that a bathroom was a necessity and entrance was a necessity, not to have another bedroom, sitting room, whatever you call it. It's not a three-season porch now, it's a four-season porch. So our intent, I think, from our meeting and why we passed it and how we passed it was very clear that an architect should be able to fit a bathroom in the size dimensions we gave them. Coming back for a minor thing like this that seems to defeat the purpose of what we're doing and why we did it. So that's my 2 cents on why I'm asking the board to find that I don't think we have jurisdiction the way I'm reading it, and it's 3 sections specifically say no, and then the one just gives the procedure for it. So I guess I would make a motion that we don't have jurisdiction and we dismiss this rehearing, reconsideration.
Okay, so if, I guess I
Is it
should
a
ask,
second for discussion? Or?
Yeah,
Yeah,
point of
right.
order.
is there a second to Mark's motion? Okay, procedure is if there is no second to the motion,
All right, I would make I guess I'm trying to figure out how I word this. I guess I went too far too fast. I guess I would, no, I guess I did make it that. Okay, I don't think we have jurisdiction. I didn't get a second. So somebody else has to make a motion now, I guess, that they, and tell me why we have jurisdiction and authority to rehear this. I guess I would point out, I don't know, but I was for a smaller size, that if we rehear this, I may bring up again that this is too big. And how do you justify it under the 3-step test that they can't fit a bathroom in a 10 by 14 foot addition, that they need to change it.
And that might be something that you could look at if you were to hear from the applicant. Now, again, we'd probably still need a motion to
Yep.
even bring this back as a rehearing and or reconsideration.
Right.
Mark does bring up good points, and really it's a matter of interpretation per the bylaws as whether or not you can hear this as a reconsideration or a rehearing or not. Be it the 12 and a half years that I've been here at Sawyer County Zoning, I know we have heard and reheard other cases in the past. Now, whether or not those were done per the bylaws or not in the past, they haven't been challenged. Nor do I believe this amount of discussion was brought up to them before. I don't know the specific cases, but I can assure you there's been 3 or 4 over the last 12 plus years that we've reheard small, minute changes after specific owners had gotten back to their builder. And instead of the 24-26 orientation one way, they switched the 26-24 orientation another way because they wanted the door on a different side. And because we approved the dimensions going 26 north-south and 24 east-west, that's what was locked in. And all of a sudden they came back and said, we're going to put the door on the other side. It really just doesn't work that way. And we'd like to flip the orientation. So it does kind of matter in what you put into motion as far as, what zoning and myself can kind of approve. And for something like this, where the motion was for a 14 by 10 and now wanting to go to a 15.5 by 9, albeit lesser square footage, it becomes difficult on me to just go ahead and approve that. That's why I did want to bring it back to this board to have that discussion and to potentially have that approval. And again, it's still that matter of procedural and whether or not we can hear it or not. I know there are other cases where we've waived the 1-year rehearing rule. But I really have to kind of leave it up to this committee to make that motion as to how they want to proceed.
Okay, for me, unfortunately, I have not missed many meetings. However, I did miss that particular meeting because it was the same night as the town meeting. So I always trust Mark on his interpretation of the bylaws. I wish I had more information in front of me on this. So the applicant's options at this point, if we are to say that jurisdictionally we do not or are not able to reconsider this, their option is to go back and start from square one and reapply. Is that correct? No, they cannot.
They would have to wait 1 year from.
1 year. 1 year.
Yeah, so they wouldn't be able to
could
reapply until
continue.
November of 2021.
Or they could continue with the size we approved.
Correct.
Excuse me, this is Barb here. Can I make a comment?
We're not to that.
It's up to the
point
chair.
yet.
Okay, that's fine.
Yep.
Let me know.
Yeah, they could continue, they could just follow through with the variance that we approved and the reasons we approved it. Or they could wait a year and come back to change it if they wanted to.
Well, it sounds like the board certainly went through all of the details and came to a conclusion of the size and what was allowed. And again, I wish I had more information, but again, if that's what was approved, well, at this point, I'm not giving opinions.
Well, I'm following your logic that we approved the footprint size, and we basically said that we cut it down because we aren't providing you with another room. We're providing you with an entrance and a bathroom.
In the bathroom, correct.
And that was our reasoning for approval. And we specifically addressed the porch part, that there's no way we could pass the 3-step test and approve this with the size they wanted and their intention of having the 3-season, or if you want to call it the 4-season now addition, that's for the convenience of the owner. There, that having a porch, a 3-season porch is not a hardship. So
Correct.
that's how the discussion went, and basically it was very clear in our discussion, because I gave most of it, that I argued for the size being reduced, that there's no hardship to approve the size they needed to put a bathroom in. And a 14 by 10 is a pretty big footprint that you can fit a bathroom and an entrance in, and changing the dimension of that little bit. If their architect can't fit a bathroom in, I mean, if the argument is they need a window in that bathroom, you can get a custom window that's 2 inches, smaller. So I guess with the reasoning we used to pass this last time, for our justification, that, I guess we could use the same justification, but looking at, before, we did not have the benefit of their new drawings, which hence why I argued for a 10 by 10 addition would be big enough. But now seeing it on paper with the architect drawing it, I mean, you're adding almost another third to their cabin. I know I'm exaggerating that a little bit. It's not a third, but it's a huge addition for a bathroom. So that's just my logic on it. And I think, I can't remember, I think Gordy made the motion to approve it. So maybe his input would help.
Okay. Other board members, comments?
This is Steve. I agree with Mark that the dimensions we approved before were thought out. They stayed in line with the existing walls. When I look at the architect's draft of the new addition proposed in the, I believe it's a 1 foot 6 inch extension for the bathroom. I don't understand why a valid bathroom, even 5 feet wide, can't fit in there. The door opening isn't set in stone. It could probably be adjusted if that was really a factor. 10 by 14 is more than adequate for a bathroom and an addition for an entryway, which is the understanding I had when the motion was initially made last meeting to approve this. I don't necessarily agree that the extension of 1 foot and 6 inches is necessary. I don't understand the necessity of it, and I guess that's my comment.
Well, we're getting a little off track. I was just trying to give a little background to Laura. But I mean, I guess our decision we got to look at is somebody going to make a motion to say we have authority to hear this, or you don't have authority.
We get to have a reason why we are doing this?
It's part of our procedures in our bylaws.
Isn't it important for you to know why we are doing it, though?
We're looking at first whether we have the authority to rehear this after it's been heard.
Right, and I guess that's what I understand after Mark's interpretation of the bylaws. That's what I understand we will be voting on, is whether or not we can actually even consider this, if we have the jurisdiction to consider this.
Okay, thank you.
Well, my motion was turned down, so I guess we got to try the other way, or somebody else can make a motion that we don't have determination, I guess is where we are.
Mark, can you remake the same motion? I have a better understanding of it, I think. I wasn't clear on whether or not, the jurisdiction portion of it, I wasn't clear on that, whether or not we were saying, yes, we will reconsider it, or no, we can't because we don't have jurisdiction.
I don't know if I can make the same motion, being it was denied. Maybe somebody else can after a further discussion. Or, because I already made it and it was turned down, so if somebody else wants to make it again.
All right.
I do have the bylaws up on the screen share there so that you guys can read what's.
Okay, thanks.
Yeah.
Thanks.
It's really kind of looking at 10.4 and then 10.6 and whether or not 10.4 coincides with 10.6, and that motion for reconsideration needs to be made at the same meeting, or if a simple majority vote to rehear or reconsider a previous decision can be made. And again, the applicant did pay for a refiling fee. I do want to make that mention as well.
Well, if we turn out we don't have jurisdiction, I would also make the motion that we refund their money due to an overlook or reinterpretation. But I guess that would be up for us for discussion. But I again would argue with Jay that they put reconsider of a board motion up there and tell you that you have to do it at the same meeting, and then they inserted that, that stops the 30-day time period, but then a simple majority vote is what you need. So you can't just say, I want a reconsideration, and they go, all right, we'll reconsider it. You have to have a vote for reconsideration. So they're telling you in our bylaws here's the process you have to follow if somebody requests a reconsideration at the meeting. So,
Okay, can I just have a moment to
Yep.
peruse this? Okay.
There's no precedent that each bullet point has to come in order. One doesn't supersede a previous one, or they can't be standalone.
No, and I won't get into it, but we've been challenged on, other portions of our zoning ordinance like that, where a top section will say you need to make and meet this requirement, and then a lower subsection talks about another requirement, and we've been told that no, that those don't coincide with each other, and that they're listed as separate subsections, where if a reconsideration was to say in 10.4, or again, if it was to say it in 10.6, that it needs to be done at the same meeting, then yes, but again, it's a matter of interpretation, and I think either way, this board would have standing to do so, and again, I know that this board has done that in the past.
I've never been involved in reconsideration. And
Okay, so Jay, if we are to refuse the reconsideration based on 10.6, our reasons would be that we felt the initial decision was correct. Right?
that there's no manifest error would be one thing we could use, and they already have their decision and nobody made a reconsideration motion at the appropriate time, to pass the time frame.
Okay, okay. Okay, does someone care to make a motion? Someone does. Give me a minute. I will make a motion to deny reconsideration of the decision, the original decision, based on the fact that 10.4 says the reconsideration should be made at the same meeting. It was not. And that under procedures for reconsideration under 10.6, we do not have a reason to reconsider it. There were no
Request.
no requests, okay, to reconsider it at the initial meeting. And we don't see a reason to reconsider it at this point. We don't feel it's within our jurisdiction to reconsider it at this point.
I would second that.
Is there discussion on the motion?
I would also potentially like you to include in your motion that they be refunded their refiling fee.
Yes.
Okay.
I
Please
would
add.
agree. I would agree with Laura adding that. I will still second with that addition.
Any further discussion on the motion? Barring any further discussion, let's take a vote on the motion. All in favor?
Aye.
Aye.
All opposed? Motion carried.
So do I get to say anything at this point?
It's up to
It's
the
up to the
chair,
chair.
but it's, we don't have jurisdiction, we find, to rehear this.
Barb, I certainly, it's not that we're not interested in why you needed to change this,
Well,
but our vote was on whether or not we had.
I understand that. I understand your reason, but when we were at that meeting, when that was all happening, you guys just decided it was going to be the size it was going to be. And it was like, we didn't really have a choice as to what it was going to be. It was going to be the 10.
You arbitrarily assigned a dimension, and we accepted that. That was great. But it didn't work for what we wanted to do, and we needed an additional foot in the bathroom, and that's all we're asking for.
Which, by the way, the footprint size is less than the original size.
We're just trying to
We're just-
get a foot into the bathroom. And yet,
we're
because of your protocols or whatever, you're denying us, and we're actually asking for a smaller footprint. So it's just,
and
you can imagine our frustration at what you're doing.
And for us to like figure out if that's going to work for us on the spot,
We couldn't.
you know, we can't do that. And this is
No, we hear what you're saying, but
the reason we're doing this is because in order to have a proper sized bathroom, it should be 5 feet wide. And right now we're at less than 4 feet wide.
you got plenty of room
No,
in
but
there.
so the other thing is that I looked at putting the bathroom on the other side. The thing is that the plumbing, we're plumbing the kitchen, and the kitchen is on that side. And so it seems sort of wrong to put the plumbing on the bathroom and then put the kitchen plumbing on the other side. So that's why we're just asking a foot and a half on that one side, and the footprint is the same.
But
and-
we're telling you, I understand, and we all understand what you're asking for and what you're doing.
I just want you to know why though.
What we're trying to explain is we're a pseudo court basically. And when we approve this, and we have to have legal justification to grant a variance. And
Your motion didn't pass the first time, Mark. So I kind of understand what's going on here, but I'm just saying you can understand our frustration. If you refund our $150, that's great. But I just have to say that you in particular, Mark, I don't know if your computer is mobile, but you made a point last time that the smallest bathroom in your house is the most popular. If you could take us on a tour of that bathroom, I would certainly appreciate it.
Well, it's a powder room. It has a sink and a toilet in it.
Can we see it? Because you're
have
very
a
proud of
camera
it.
that moves.
You're very proud of it. You think that everyone should have a powder room like that. You said it was the most popular powder.
Excuse
Lauren,
me.
you don't need to have this continue at this point. If you'd like me to mute them, you certainly can ask.
Excuse me. This can't go here, okay? And I understand your frustrations, but what we were voting on this evening is whether or not we had the jurisdiction to reconsider this this decision. And we have decided we did not have the jurisdiction.
I've since muted them. If you'd like me to unmute them so that they can continue to have conversation, you can let me
I
know.
We can
Chairwoman?
move on. Point of order, move on.
I didn't realize they were muted, and I was just trying to explain what we voted on, not whether or not they needed an additional foot, but this is going nowhere to argue this about Mark's bathroom, and so anywhere.
Right, and they can still hear you at this point. It's just I've muted them.
Okay.
Unless you would like me to
fine.
unmute them, I certainly can.
That's fine, but that conversation is taking us nowhere. That was not what our decision was based on.
Moving on to number 2, this would be a reconsideration, and again, this is just for discussion of Big Fish Variance 20-004. This was a variance that was approved at last month's Board of Appeals for a sign for Big Fish Golf Course. I have since been asked by the applicant for a reconsideration/rehearing to add LED lighting onto the sign. And be it that the motion for not hearing the reconsideration of Betts was just initially approved, I don't think any additional discussion for this one would need to be made, and they will need to wait a 1-year refiling period to hear any additional variances for the sign for the Big Fish Golf Course. If this committee or this board would like to have any further discussion on that, we certainly can.
I concur with your assessment of this situation, Jay.
Ms. Chairwoman, I would think the board maybe should look at maybe making some changes, looking at other Board of Appeals. I did find one that I sent to Jay. I don't know if he has it on his computer, but where they do allow you to rehear some stuff and they have a little more latitude. I think we'd have to rework theirs a little bit, but I don't think that would be a decision for tonight, but I think maybe if Jay can come back to us at our next meeting, if we have one next month or whenever our next meeting is, with maybe some language we could look at for cases like these two that came up tonight, that might give us more latitude to look at doing something.
Yeah, and I believe we're on probably number 3 of the agenda, so this would be any other business that would come from the committee. I'm not going to rewrite your bylaws for me, but if you want to add certain things like that as potential caveats within your bylaws to rehear minute changes or something to that effect, I can look at language to add into that.
Or
Again, I mean, the last amendment to your bylaws was done in 2014, so you're looking at 7+ years ago now, or 6+, I should say.
well, maybe what I'll do is I'll send something to you as just for a discussion item with some language that maybe you want to look at. We can decide if we want to go further or not. I can submit something to Jay to get in our packets at our next meeting if we want to do it that way.
I get my confusion here then is, so what's the difference between, okay, so again, I wasn't at the November meeting, but here's the size that we think is fair, and you can certainly fit a bathroom and an entry into this. And then at that point, they say, well, really, that doesn't work for us. Or they're shell shocked and they say, well, okay, if that's all we get. So at what point do we say, okay, you want to come back next month with you want to refigure this, you want to, or talk to your architect again, or do we start from scratch all over again, or do we just deny based on what the bylaws say?
Right, and that's there's actually going from our Board of Appeals handbook, they kind of address it that basically says in 1998, the Court of Appeals upheld the Board of Appeals rule that prohibits hearings, reconsiderations, and new applications seeking the same relief after a previous denial unless there has been a substantial change of conditions or circumstances since the decision. And they ruled that it served a legitimate purpose because it promotes finality of zoning board decision and avoids the inefficiency that results from revisiting the same issues when there has been no change of circumstances. And they also went on in an earlier case, and they cite the cases. The court observed that a zoning board should not reopen or reconsider a proceeding that has been terminated, although there are possible exceptions such as mistake, public necessity, or good cause, such as a significant change in circumstances. And they cite the 2 cases in it. So that's kind of what our zoning handbook says, that, if you got to have finality, otherwise, like you just said, they could come back and the architect change something again and come back again.
And right, and so how many times do you do that? I guess that's my thing. How many, okay, so we're going to come back in February, then we're going to come back in March, and you didn't like that in March, and all right, I'm going to have them redo it again, and we'll be back in April, and it's still the same case.
Right. And do you have to come up when they change it? I guess I didn't go any farther on that, but you know, when this comes up, you know, Jade said that they didn't send letters out to the people, but technically, should they have, being it's a case that's been noticed in the paper and it affects the neighbors, that do we have to go through and do the whole procedure over? It went to the town and then it, you know, came to us. So do you have to do the whole thing? So then do we have to look at this de novo, or do we have to look at this as we have to rehear the whole case and come up with reasons for approval, denial? I mean, I don't know. Did they run the risk of that? You know, you weren't there and Al wasn't there at the last meeting. That if you and Al were here, that maybe it would have got denied this time if we reheard it.
Yeah, right,
So
right.
I don't know if that's a risk or if that's the way we would proceed, but that's definitely one of the possibilities. If we're rehearing it, you're rehearing the case. So does that mean if we come to a different decision, we have to justify it? So just questions that it opens up a Pandora's box if we keep proceeding down there. I mean, just tonight we had two that were already decided. So
Yeah, and I think the argument could be made for the actual applicant that there has been a change in circumstance in that their initial request was reduced to amount in which they weren't familiar with what dimensions they needed, then figured out that that 62 inches on the same wall as their internal plumbing would be has now been where they need to, in essence, situate a bathroom, which again, now they're having to fit a toilet, a sink, and a shower in 62 inches of width because that internal door on the historic cabinet is not going to get moved. So I could make the argument the other way that there has been a change of circumstance because of the reduction in size from the requested variance.
Okay, I see that. Correct. But then again, that's not what we were voting on tonight. Right.
Correct.
So what I guess where we are is, do we want to look into changing our bylaws, or at least looking at some language to see if the language is something we think it will accomplish the purpose of allowing something like that?
Right. So if we say at the end of a meeting, we say, okay, we've considered your request and we're not going to allow a 10 by 14, but we'll allow a 10 by 10. They are not at that point going to be prepared with a new plan to try to fit things in. So are they just shut down, shut out, or do we say, come back to the next meeting, and then how long do you do that? And so this really does open up a whole can of worms on reconsiderations.
Yeah.
The term reconsideration versus coming back to the next meeting, because there has been, as Jay just said, a change in circumstance. You presented a plan with a certain dimension, and now your dimension has been changed, so you can't expect to recoup that quickly. Anyway.
Yeah.
I think that was the point they were trying to make. And it is somewhat of a difficult formality that we're working within those bylaws for that. And I do wish there was some flexibility, not that flexibility be given to me, but at least given to this board, that they can hear those small, minute changes based on some type of change of circumstance where we allow those types of avenues to come back. And maybe it is, through a reduced application fee amount. And if it's, such of a minute change that hopefully it doesn't need to go, again, looking at the one we have in front of us, this is a 14 by 10 for 140 square feet, where they wanted to slightly change it to a 15.5 by 9, which is 139.5 square feet. I mean, you're talking about one of the most minute changes that I've ever seen on an application, where if we have to send this back out as an official public hearing and give it all the way back to all the adjacent property owners, well, then it's not going to be a reduction in the amount, because that's a $500 change to make a 1.5 foot correction on. I just wish there was some common sense that we could put into bylaws to potentially allow for these, or maybe we need to get more flexible on our motions, where we just, instead of giving, a certain dimensional requirement, like a 14 by 10, we say 140 square feet and, no further than 2 feet on either of the side walls in line with the back of the cabinet. It's something that gives them a little bit of flexibility moving forward without having to come back in for these types of scenarios.
Yeah, that gets
Yep.
hard to remember to do something like that when most of the stuff we do is approving footprints. That, I don't know. I think it's probably a good idea that we, look into. Like you said, it's been 7 years since we've looked at this, and there may be other things that we want to look at the same time. I was looking at another Board of Appeals, and most of them follow ours, and they're all pretty generic, but they had expanded theirs a little bit more. I'm looking at it right now, but just to give you a sense of what another board did, it said exception. The board may not act upon, just like ours, it can't be considered again with 1 year from the date of action, except as provided under section 2, which is exception to the 1 year rule. It says the board may hear cases within said 1 year period commencing the same property only when the case does not involve a request for an identical permit, so that wouldn't have applied here. The case does not contain the original request, which that doesn't apply. Substantial change in the use of the adjacent property has occurred, so that doesn't apply. So nothing on theirs for the exception to the 1 year rule applied, but then they go further and then they get to their section 5, which would be almost identical to ours, reconsideration on board motion. But there they added, we have motion to reconsider made at the same hearing may be immediately disposed of without further notice. But then they also add a B, which we don't have, which says by motion to reconsider made not later than the following regular meeting, in which event the minutes have not been approved and the matter shall be placed on the agenda for the subsequent hearing and a new notice given without additional fee. So they're saying they're giving the people up until we approve our prior minutes at our next meeting, they can ask for reconsideration, and then we take a vote on whether we would rehear it, and then the rehearing takes place the next month. So I don't know if that's something we might want to look at or not. That's just one other board, but like I said, I looked at a whole bunch of them, and pretty much all of them have the language very similar to ours. So one town or one county at least did look at putting a little flexibility in, but whether we want to or not, I guess we can look at putting something together and seeing if we want to entertain it or not in the future.
I really think that is something we should be looking at. I mean, there's, in just the two this evening, okay? If there's somehow that we can use verbiage that gives us the authority for reconsideration, after we've changed the original request. So if we can reconsider configuration to fit what we allowed them to have, if it's not going to change the footprint or it's not going to encroach more upon the shoreline, that can be at the discretion of the board. So
Yeah, we'd,
what I'm saying is at the end of the meeting, if we say 10 by 10 when they asked for 10 by 12, and they have to reconfigure things, that if what they bring back to us the following month is still within the footprint that we allowed them to have, and it is not encroaching more upon shoreline, that it should be at the discretion of the board to hear it another time. Not indefinitely, of course, not February, March, April, May, June, but when you hit an applicant with a change in
yes,
size,
hard.
it's hard to automatically come up with a new plan before the end of the meeting.
No, I agree, and I think, like I said, I can forward this on to Jay, and he can look it over, and we can maybe come up with something to present to the board just on this, if that works in the future.
But
To
Mark,
give us some flexibility.
what you did tonight was right according to the bylaws. And that's the way it is. And
No, and you know, we're always the bad people, but we got to follow what's laid out in front of us, because anybody that appeals our decision goes to circuit court, and we gotta, you know, we gotta put our, you know, our information that we're following everything on there. I mean, if we don't follow our bylaws, then, and, you know, some of these are minor, some are probably are more major, but, you know, I agree this one, I would have liked to have heard it, but I don't, being we're trying to get everything following the correct legal procedure, that I myself, I couldn't see how we can do it. So,
okay. We're done hashing that over. Is there anything else? My agenda did not have the LCO thing on it. Is there any other business?
nope, I think we just finished that.
Yeah, we, based on our bylaws, wouldn't be able to do any type of reconsideration or rehearing for Big Fish, and I'll let the applicant know that they'll have to wait the 1-year refiling period and
Okay.
reapply.
All right, barring any other new business, do I have a motion to adjourn?
I'll make that motion.
I'll second
Oh.
that.
Motion carried, meeting adjourned. Hey, Jay, you got Al's phone number?
I don't, not off the top of my head. I could go look for it.
I'll be looking it up.
All right.
Thanks.
Thanks.
And
Yep, take
everybody, thanks for bearing with me. I was very ill prepared for this. I count on Al to be there, so I'm so sorry. And Mark, thanks for all your help. Jay, thanks for all your help.
You're welcome. Have a good night, everyone.
Yep, thank you.
Bye.